Good morning, this is your Kelso Report for Friday, September 21st, and I'm your host, Clark Kelso. We have a couple of cases today. First, we review a decision with the Ninth Circuit affirming a district court's approval of a cypre settlement in a class action involving Facebook. And then next, a decision by the Second District involving Los Angeles County's possible tort liability for failing to capture and detain two dangerous pit bulls before they injured a young boy. Then we begin with the Ninth Circuit and Facebook. It is well understood that the named plaintiffs in a class action, or putative class action, and plaintiffs' counsel have obligations to conduct the litigation in the interests of all class members, and not just to the benefit of the named plaintiffs. The question of whether class plaintiffs and class counsel have fulfilled those obligations frequently arise in the context of a proposed settlement of a class action, where almost invariably the plaintiffs are giving up something in return for the settlement. Other class members may think the named plaintiffs and counsel have given up too much in the settlement negotiations, and the law protects the class members' interests by requiring that a district court's approval of a class action settlement must be accompanied by a finding under Federal Rule of Civil Procedure 23E that the settlement is, quote, fair, reasonable, and adequate, close quote. Once the district court has made that finding, getting an appellate court to overturn a class action settlement is very difficult, because appellate review of the district court's fairness determination is extremely limited, and the appellate courts will set aside that determination only upon a strong showing that the district court's decision was a clear abuse of discretion. These legal issues were before the Ninth Circuit in McCall v. Facebook, where the Ninth Circuit was asked to review a district court-approved settlement in the amount of $9.5 million in a class action involving an alleged breach of privacy associated with a particular Facebook service, now discontinued because of the lawsuit, known as the Beacon Program. The primary argument made by the objectors to the settlement was that most of the money was directed to a cypre distribution directed to a newly created nonprofit that's focused on digital privacy education, where one of the three directors of the nonprofit was a high-level official employed by Facebook, namely Facebook's Director of Public Policy. According to the objectors, this created a structural conflict that made the distribution and the settlement unfair. The Ninth Circuit rejected this argument, noting that as the offspring of compromise, settlement agreements will necessarily reflect the interests of both parties to the settlement, including those of the defendant. The court also rejected the argument that the settlement amount was too low, noting that most of the class members would have only a de minimis damages award, and that the overall amount of the settlement was fair and reasonable. So once again, good evidence that once a district court has found the settlement to be fair, the appellate courts are really loath to intervene. Next, we turn to a government liability case coming out of Los Angeles. Because of the doctrine of sovereign immunity, federal and state governments are immune from suit unless they have consented to be sued, which usually means there must be a statute that specifically authorizes a suit against government. Now, over the years, Congress and state legislatures have enacted many statutes waiving sovereign immunity in particular classes of cases. Of course, suits like breach of contract and many types of torts. Those statutes define the type of suits that may be brought, and when you don't have a statute, define what cannot be brought. In California, pursuant to Government Code Section 815.6, a public entity may be liable for injury caused by its failure to discharge a mandatory duty imposed by an enactment designed to protect against that type of injury. Now, there are literally thousands of statutes that direct government agencies to do things, and many of those statutes say that an agency, quote, shall, close quote, perform some function. But that language is not enough to trigger liability under Section 815.6. As the California Supreme Court has noted, to be mandatory under that statute, the enactment must be obligatory rather than merely discretionary or permissive in its directions to the public entity. And in addition, it is not enough that the public entity or officer have been under an obligation to perform a function if the function itself involves the exercise of discretion. That's why an enactment's use of mandatory language such as shall is not dispositive. An enactment creates a mandatory duty only where the commanded act does not lend itself to a normative or qualitative debate over whether it was adequately filled. Well, the question in County of Los Angeles versus Superior Court was whether the County of Los Angeles had a mandatory duty under that statute to capture and take into custody 2 privately owned pit bulls before they attacked one of the plaintiffs in the case. The trial court concluded it did have a mandatory duty, based on certain provisions in the Los Angeles County Code, which, when read together, require the director of the County Department of Animal Care and Control to capture and take into custody any animal that, quote, constitutes or causes a hazard or is a menace to the health, peace, or safety of the community, close quote. The Second District sensibly reversed, holding that the language in the code did not create the sort of mandatory duty that triggers liability under Section 815.6. According to the court, the Director of Animal Control's statutory obligation is still one that involves the exercise of discretion. So it is not the sort of unambiguous and obligatory directive that falls within the scope of Section 815.6. Because of this interpretation, the result in this case is to grant summary judgment in favor of the county and against the suit for damages liability, which had been brought by a boy injured by the pit bulls. Seems to me any other result, doing what the district court did, essentially leads to every dog bite case in the state, or at least in Los Angeles County, suddenly giving rise to a lawsuit against the county dog catcher for failing to catch all of the dangerous dogs. That's not likely that that's what the County Board of Supervisors meant in enacting that portion of the county code. And that's it for today's Kelso Report. Have a great day in the law.